Today we are going to be looking at the area of labour law. The terms labour law and employment law are often used interchangeably. However, technically speaking, labour law refers to the statutory rules governing labour relations, whilst the term employment law refers to individual relations between employers and employees. In common law countries, employment law is fundamentally governed by the contract of employment signed between the employer and the employee. Unlike in some civil law jurisdictions, pre-established employment agreements are unusual outside of collective bargaining agreements, and thus each party is in principle free to enter into the agreement of their choice. The general approach of common law jurisdictions in the area of employment law is not to define individual conditions of employment, but rather to establish a basic minimum level of statutory protection applicable to all employees. This is because the principle of freedom of contract goes to the heart of the common law system, and consequently people should be free to enter into the employment contract of their choice. Some examples of the minimum rights that must be respected by employers in some but not all common law jurisdictions include the right to a minimum period of holidays, the right to receive a minimum wage, the right to parental leave and maternity leave, paid notice in the case of dismissal. Now let's look at the issue of dismissal. Dismissal is often a reflection on the inability of an employee to perform the job asked of him. However, more generally, it can result from a change in the business direction of the enterprise in question or from a downturn in economic conditions. In all business cycles, there are periods when employees are hired and periods when it is necessary that they be dismissed or made redundant if the business is to remain profitable for its investors. The laws of different common law countries provide limited protection for employees so as to prevent unfair dismissal. In most US states, employees are employed at will. This means that an employee may be dismissed or fired or sacked at any time unless the employment contract provides to the contrary. However, even workers employed at will cannot be fired illegally, for example in breach of federal labor laws such as the Civil Rights Act of 1964 or the Americans with Disabilities Act 1990. On top of the protection provided under the heading of federal law, individual states remain free to offer employees better protection, as is the case with Montana, for example. Although each American state offers different levels of employee protection in cases of dismissal, it can generally be said that employees enjoy greater statutory protection in the United Kingdom than they do in the United States. In the United Kingdom, if a worker has been employed full-time for more than a year, he may only be legally dismissed for one of the following reasons. 1. Misconduct. Where an employee refuses to respect the rules in force in a business in which he works, he may be dismissed. Frequently, it is required that the employee be given a number of warnings before dismissal becomes acceptable. Moreover, the rule that has not been complied with by the employee, i.e. the basis of his or her misconduct, must be reasonable in character. Redundancy. If a company shuts down completely, closes one of its divisions, or restructures its business in any way, redundancies often result, and the employees may be made redundant. Such reorganization is normally a feature of larger companies which often have a syndicated workforce, and the company will normally negotiate the redundancy program with the trade union in question before implementing the reorganization program. If the redundancy concerns more than 20 employees, there is a legal duty on the employer to consult with the company's trade union or elected staff representatives where there is no trade union. In order for the redundancy program to be considered legally justifiable, the restructuring or reorganization must be genuine, i.e., there must no longer be any need for the worker to do the job entailed by the post that has been suppressed. Finally, redundancy compensation must be paid to the employee. Ineptitude, inability. If an employee is not doing his job properly or does not have the necessary qualifications for the job in question, he may be dismissed. An employee may also be dismissed in the case of a chronic illness which results in his being unable to do his job. If an employee is dismissed for a reason other than those listed above, it is probable that the dismissal is illegal, and consequently it will give the employee the right to receive damages or compensation. There are three categories of illegal dismissal, but they are not mutually exclusive and in reality can overlap. The first category of illegal dismissal is unfair dismissal. In the United Kingdom, unfair dismissal is considered to occur when an employee is employed for a period of over 1 year and is dismissed for a reason not coming within the three categories set out immediately above. The term unfair dismissal is relied on less in the United States, but if used, it normally refers to a situation where an employee is fired unfairly and not necessarily illegally, i.e. in breach of a specific legal provision. If an employee is let go in violation of a law in the United States, the dismissal is often characterized as wrongful. The second category of illegal dismissal is wrongful dismissal. In the United Kingdom, wrongful dismissal normally occurs when an employee is dismissed in violation of the terms of his contract of employment. For example, where an employee is fired without the employer respecting the applicable notice period. Unlike in cases of unfair dismissal, there is no requirement that the employee be in employment for a period of over 1 year. In the United States, the term wrongful dismissal can extend beyond situations linked to the employment contract so as to include dismissal in violation of an applicable statutory law. For example, if under law employers are meant to consult with staff representatives prior to triggering a redundancy process and they fail to do so, any resulting redundancies will be classified as a case of wrongful dismissal. The third category of illegal dismissal is constructive dismissal. Constructive dismissal is said to occur when an employee leaves his employment as a result of the hostile employment environment created, promoted, or tolerated by the employer. Now let's quickly look at the area of disciplinary hearings. If accused of a disciplinary offence at work, for example stealing from a colleague, the right to a disciplinary hearing exists. In the United Kingdom, the procedure to be followed requires that the employee be given reasonable notice of the hearing, allowing for a sufficient preparation period, be informed in detail as to the nature of the alleged offence, be accompanied during the hearing by a fellow member of staff, and be shown any evidence supporting the accusation. Now finally, let's look at discrimination in the workplace. Discrimination may take many forms, but two basic categories of discrimination are recognized: direct discrimination and indirect discrimination. Direct discrimination. Direct discrimination is said to occur when an employer behaves in such a way that the employee is directly treated less well than other employees. For example, a restaurant manager who refuses to hire an applicant for a position as waitress because of her color. Indirect discrimination. Indirect discrimination results from a business having in place a rule that, although applicable to everyone, is in reality unfair to one group of employees. For example, a rule that requires all waiters or waitresses to be over 180 centimeters tall, which will, of course, indirectly discriminate against women and smaller people. Damages available to employees resulting from discrimination can be significant, reflecting the importance given to eradicating this blight from society. This is particularly true in recognized sensitive areas such as racial or sexual discrimination. Compensation will normally be awarded under the following headings: loss of wages, injury to feelings, and personal injury. We hope you enjoyed this introduction to the area of labour law.